Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. I'd like to welcome you to this morning's webinar, brought to you from Harrisburg, where it was warmed up to a balmy 15 degrees. This morning, we're going to be talking about the right to know law and its application for the law enforcement community. But a couple preliminaries before we get started. If you've never participated in one of these webinars before, first off, and welcome. But it essentially is a PowerPoint presentation with me talking along with it. The PowerPoints and the PowerPoint for this presentation in particular is available on our website. You would go over to the training tab and scroll down, and you can find all of the PowerPoints that we use for our training. And feel free to download them for free and use them as you see fit. It may be possible that you have a colleague who wasn't able to attend this morning and they can refer to it. You can use it for your own future reference. Maybe you've got some localized training that you need some resources for. And again, feel free to access any of those PowerPoints and use them as they would prove helpful. This session is being recorded, and the recording is or will be available on the website as well in a couple days. What happens is after the session, excuse me, our administrative staff will first upload the recording to our YouTube channel, and then they create a link from the YouTube channel to the website. So probably, within 3 or 4 days, you'll be able to find a copy of this recording available on the website. Same rules apply. It's a public record. It's free. Maybe you have staff who you'd like to include in some training. They can refer to the recording after the fact, as well as yourself. Maybe you need it for some future reference. Have at it. All of our recordings, they're usually of the most recent session for that particular topic. So feel free. And then, well, we'll just leave it at that. Okay, so if you have questions, feel free to type them in the chat feature, and I will do my best to answer your questions as we're proceeding through the session. If it looks like, well, first offhand, two conditions or two favors that I would ask. First offhand, we are talking about the right to know law for law enforcement, so let's do our best to stay on topic. That's the presentation this morning. Second, and probably more important, is try to keep your questions as brief and succinct as possible. And reason being, it's every so often someone will type in several paragraphs, and it's just awkward for me to sit here and read through all of that while everyone else is waiting patiently for me to respond. Look, if it is an unusually complex question or something unique to your situation, we'll do one of two things. We'll wait until the end of the presentation and I'll come back to it and answer it for the good of the order, or we'll take the conversation offline. There's contact information on the screen right now where you can either call into the office or go to our website where you can find email accounts for contacting the office. And what happens is one of the administrative staff will be your first point of contact. And they're very well versed in all of this, and they can usually get you headed in the right direction. If you happen to stump them, your question will get escalated up to one of the senior staff, and they usually are able to get back to you within 24 hours. We realize that if you're reaching out to us, it's probably something time sensitive and important, so we want to get back to you as quickly as we can. Now, we can't write requests for you. We can't answer requests for you, and we cannot discuss anything related to an active appeal. Okay, that's between the parties and the appeal officer. Also, we can't provide legal advice, but there is a very good chance that whatever you're contacting us about is something we've already dealt with, and we can direct you to decisions or court cases that have been made that, again, will hopefully shed light on whatever your question is, and like I said, get you headed in the right direction. Okay, I think that takes care of all the preliminaries, so let's dive into this. And like I said, we're going to talk about the right to know law as it applies to the law enforcement community. And we do that because there's a lot to know about the right to know law. However, for law enforcement, we figure you've already got a full plate. And what we've done here this morning is break it down into just those areas that looking at it from a law enforcement perspective, okay, what do I need to know about this law so that I can at least get the ball rolling when we get a right to know request? What sort of things can we do? What sort of things can't we do? So I want to begin by taking a look at, why is the right to know law important in the first place? And bear with me here, but um, it's a matter of public access to public records, uh, government transparency, and in general, just good government. And of course, I'm going to say that because I'm working for the Office of Open Records. We're the state office responsible for government transparency for both state and local governments. And we just view this as very important. But I think, there is a fundamental statement that I always begin these right to know sessions with that I think it's important for everybody to be familiar with. And it's to keep in mind that the purpose of Pennsylvania's right to know law is to give the public access to public records. Okay. That's what the law is intended to do. No more, no less. And I always put this in there because there's a lot of misunderstanding, especially when people see that term right to know. They view it as some form of government Google where they can, just generally ask questions about anything they want to, and it's our job to go out and find the answer. And that's not the case. A lot of times when you're dealing with right to know requests or open records requests, which is the same thing, um, it's what you need to bear in mind is that uh, your job, or the job of the agency, I should say, because I'm assuming we have some members of the public here with us, is to provide public records in response to that request. Okay. It's not the job of government to run around and answer questions that people just scribble out on a right to know request. Um, Now, people will see this law. Maybe, you're a new open records officer and you get your first right to know request, or maybe you work in an office and you suddenly find out that, oh, there's this thing called the right to know law, and you break out into a sweat and panic. It's like, oh my gosh, everything in the office is going to show up on someone's Facebook page tomorrow, or maybe on the front page of the paper or some news website. And I'm here to tell you that that's not the case. There are quite a few what we'll call tools built into the right to know law that we'll talk about here this morning that, if you get a right to know request and a red flag goes up and you're thinking, I just don't feel comfortable that something like this document should be released to the public, there's a very good chance that one of these tools would apply and would provide you with the basis for not releasing that record into the public domain. Okay, now I'm not going to say that's always going to be the case because there are some records that are inherently public just by their nature. But for law enforcement in particular, we're going to talk about tools that could allow you to withhold records from being released into the public. And hopefully you'll see the logic why. Okay, but all that being said, when we start with a right to know request that's received by an agency, and when I use the term agency, here we're talking about police departments for the most part. But when a right to know request is received by the agency, the starting point is that all records in the possession of an agency are presumed to be public. That's where you start from. And then it is the agency, the police department, that bears the burden of proving that a record is not public, okay? So if you fail to meet that burden, essentially the record being requested is public and it will be released. Okay, so that sounds rather daunting, okay, but we're going to talk about the tools that are available that allow an agency to meet that burden of proving why a record is not public. Okay, so we're presuming that the agency is subject to the right to know law, that it falls under their jurisdiction. Most police departments do. It would be difficult to find a police department that would fall outside of the right to know law. So there are some things that you have to do. First, and probably most important, is that you need to appoint an agency open records officer, what we call an ARO. Now, there is no difference between like a right to know officer and an agency open records officer. The two are interchangeable. Okay, now this person needs to be either an official, a public official, or a public employee. Can't be a volunteer. And there's no requirement that they be at a certain level within the department. It could be non-uniform staff. It could be the chief of the department. The right to know law does not distinguish in any way. You can have more than one right to know officer. And some will have like a main right to know officer or a open records officer, and then they'll have an alternate in case that other person is on vacation or out of the office for an extended period, whatever. It just needs to be clear to the public who this person is, which means you need to post contact information. You look at this from the public's perspective, okay? They need some sort of record, but they've heard about the right to know law, but they don't know how it works. So do your best to educate them before they even walk in the door. Okay, this is how the right to know law works within our department. So this is the person you need to contact, and this is how you get a hold of them, whether it be phone numbers or emails or whatever. You have to have a form available for them. Now, if you have a website, this information needs to be on your website. So you would have the form on your website. But you also need to have forms available so that if they come walking into the administrative office and say, I'd like to file a right to know request to get a record, you can hand them a form to fill out. Okay. You must have available all the applicable appeals information. And for law enforcement, the appeals process can be a little different than everybody else. So we'll talk about that towards the end of the presentation. But you need to be able to tell people that if you turn them down, if you deny their right to know request, this is what they can do if they want to take it further. And you need to instruct all staff that if someone hands them a right to know request, like let's say you've got an officer, he's taking his lunch break and he's sitting, in a local restaurant having a burger or whatever. Someone comes walking up and hands him a right to know request. Well, they're allowed to do that. But you want to make sure that all your staff know that if they get a right to know request, they need to forward it immediately to your agency open records officer, to the ARO. Okay, no delay. All right, because there are hard deadlines built into the right to know law, which we'll discuss, that you could abrogate the agency's ability to meet its legal burden by missing a deadline through your failure to get the right to know request to the right person as soon as possible. Okay. If there's any undue delay and that deadline lapses, it could cause some serious problems. Okay. So all staff are trained. You get a right to know request, get it to the ARO right away. And then you want to notify us here at the Office of Open Records who your AROs are. Okay. And that's because on our website that I referred to earlier, we have a database of AROs statewide. Sometimes people will contact us. It's like, I looked at the website, I tried to find out who this department's ARO was, and there's nothing there. Okay, can you help me out? Well, we'll direct them to the database on our website. And if there's an appeal filed with our office that involves your department, that's where we go to find who the contact person is. Because the agency open records officer is the person legally responsible for receiving, processing, and responding to requests. So we need to know who those people are. Now, one of the takeaways from this morning is you can go to our website, double check who the contact information is for your arrow. And if it is outdated, and we realize, people move on, they get promoted, they retire, whatever. If the information is outdated, there's a form available that you can fill out, email it to us. We'll verify it and then update the database. All right. But you want to do that. Make sure your contact information is accurate. Again, look at all this from the public's perspective. This is an opportunity to educate them into how the process works, because the more informed they are, the easier it will be for you in processing the requests and potentially getting them whatever records that they're seeking. Now, there are some things that you cannot do under the right to know law. So let's talk about that. You cannot adopt a policy that would limit the number of records that a person can request or the number of right to know requests that they submit in any specific time frame. You can't say something like, ma'am, I'm sorry, you've already submitted 3 right to know requests this week. That's all we allow. If she's inclined to submit a dozen right to know requests, the law allows her to do that. Now, let me step on my soapbox for a little bit and just say that the greater majority of people who avail themselves to the right to know law have a legitimate need to acquire public records. But there are a handful of people out there who, for whatever reason, the relationship between the agency and them has broken down. Maybe you gave them a parking ticket. Maybe they got a speeding ticket that they don't agree with or whatever. Maybe they just don't like you. So they've weaponized the right to know law, and they have a habit of submitting what you believe are frivolous requests. I would recommend that you sit in on our webinar that deals with payment issues, because I've worked in this area now for, with the Office of Open Records directly for 10 years, and I'm going on my 2nd year as a consultant now. I find that the solution to dealing with problem requesters is on the payment side of the right to know law. Okay, and I'll just leave it at that and sit in on that session and you'll be able to figure it out. But getting back to the topic, the other thing that you cannot do is require a person or compel a person to tell you why they are filing a right to know request. Okay, and admittedly, this goes back to what I was talking about, where some people file right to know requests just to see you work harder. Sit in on that webinar and I'll answer some questions for you that deal with that. Okay. And if you happen to be one of these problem requesters who are joining us today, well, shame on you. Please don't do this anymore. All right. But you cannot force a person to tell you why they are filing a right to know request. Okay. Let's take a look at the process itself now. I like to describe the right to know process as an obstacle course. And the start of the obstacle course is when you receive the request. You've got these hard deadlines that are built into the law that are very similar to what I'll call time standards. That, for instance, you cannot enter a race unless you're good enough. Okay, so you're put into categories that are based on time standards from previous performances and so forth. Then on this obstacle course, you've got 2 hurdles that you've got to jump over. But in front of the second hurdle, you've got 3 hoops that you need to jump through before you even get to the hurdle. Okay. And what I want to do now is walk you through this obstacle course so you have an understanding of the right to know process. Okay. So let's talk about these deadlines, because this is important, like I was talking about earlier. When you receive a right to know request. When the agency open records officer receives a right to know request, they have 5 business days in which to provide an initial response. Now, a business day is, first offhand, it's your business day. Now, most police departments are on a 24/7 operation. But for our purposes, a business day would be when the administrative office is open for dealing with the public. So if it's a holiday, for instance, if your administrative offices were closed for the Martin Luther King holiday, that would not be considered a business day. If there's a snow emergency and the administrative offices are closed, that would not be considered a business day. Saturday, Sunday typically would not be considered a business day. So it's 5 of your business days. And if you were to receive a right to know request today, tomorrow would be your first business day. And then you would count accordingly. And at the close of business on the 5th business day is when that initial response would be due. Now, let's say that you would be unable to provide a final response within the 5 business days. Okay. And a final response would be something to the effect we're either granting your request or we're denying your request. So if you can't do that for whatever reason, well, for specific reasons, you're entitled to unilaterally invoke a 30 calendar day extension that would become effective on what would otherwise be the 6th business day. Now, a calendar day is different from a business day. A calendar day would include a holiday. It would include an emergency closing. It would include Saturdays and Sundays. You simply look at the calendar, count 30 days, and then that's when that would be the deadline at the end of the 30 calendar days. Okay, the first 30 calendar day extension can't be rejected by the requester, even if they believe it's not justified. Correct. Yes, Walt, that is correct. It's unilateral. But in order for the extension to be valid, there are some conditions to be met. First, it needs to be invoked within the 5 business day window. You can't wait until the 6th business day, suddenly realize, oh gosh, I forgot about this right to know request. Well, we'll just take an extension. Unfortunately, by missing the 5 business day deadline, you have de facto denied. It's what's called legally a deemed denial when you miss the deadline. Okay, so you need to pay attention to the calendar. Then you need to notify the requester in writing that you're invoking the extension. And this, if it's submitted by email, you can respond back by email that you're taking the extension. You need to provide them with a reason as to why you're taking the extension. And if you go to section 902 of the law, it lists 6 reasons. Okay, for instance, it could be that these records are kept off-site. It's going to take us longer than 5 days to go look through them to see what we can release. Or we want our solicitor to review these records to make sure we're not giving away anything we're not supposed to. And it's going to take the solicitor longer than 5 days. Okay, so we're invoking the extension because of that. Then you notify the person when they can expect to get the response, which typically is the 30th day of the extension. Okay, so you've got the 5 business days and then the 30 calendar days to work with in providing a final response to the requester. And then there's another deadline that you need to keep in mind, and that's if you deny a request, the person who filed the request has 15 business days in which to file an appeal with the appropriate office. And again, we'll talk about appeals towards the end of the presentation. But that's a deadline that you should be aware of, because remember, you have an obligation to notify the requester in your denial letter that they can file the appeal within the 15 business days. All right, so we've come up on the first hoop of the obstacle course. And to get, or I'm sorry, the first hurdle. All right, 15 days from the denial or 15 days from the, let's see, 15 from the day of the denial or 15 from the 5 business days. 15 days from the date the request was denied, whether it be within the 5 business day window or within, if you took an extension. It's based on whenever, actually, it's based on the date of the denial, whenever you would issue that denial. Okay. So if they denied it on day 2 of the 5 days, then it's 15 days from them. Yes. Okay. Good, Walt. Good. Okay. Good questions. Keep them coming. All right. So we're at the first hurdle, and we have to answer the question, is it a record? All right. Well, whenever you're trying to understand a law, I always recommend that you go to the definition section, because quite often there's parts of a law that are written in legalese. They're hard to understand. It may be vague. You may, in fact, find what you believe to be conflicting language, and it doesn't make sense. You don't know what to do. Oftentimes, you can shed light on the issue by reading the definition section of the law, and the right to know law is no different. So we have to answer the question, is this person asking for a record? Well, yeah, but within the right to know law, there's a definition of a record. That definition is any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Aha. Okay. So why is this important? Well, because all day long, we generate communications that do not rise to the definition of a record. Okay, now the key phrase is highlighted, documents a transaction or activity of an agency. So if I send an email to one of my coworkers, hey, did you hear about the new restaurant that's opened up downtown? Let's meet for lunch tomorrow. Okay. Now I sent that on my work computer, on my work email. Okay. You'd think that's a record. Well, it's not, because it in no way is it documenting a transaction or activity of an agency. All right. It has to be about the department, about the work that we're doing, about the mission that we're tasked with carrying out. And where we go to meet for lunch tomorrow is no reflection on that whatsoever. I could be asking, it's like, well, what kind of trades do you think the Eagles are going to make to have a better showing next year? Do you think Jason Kelsey's going to retire? What's up with, the coaching and so forth? Who knows? But that has nothing to do with the department, but yet it's reflective of very common communications that you can find being sent within an agency. So because they don't reflect a transaction or activity of an agency, they don't make it over that first hurdle, and they're off the obstacle course, okay? Those sort of communications are not defined as records. Thus, they're not what we'll call discoverable under the right to know process. Question has popped up. Walt's very busy here this morning. If a police officer is using their cell phone, okay, you're like a nanosecond ahead of me. All right. Now, what if an officer or any member of the department uses their personal cell phone to communicate department business? All right. Those messages are discoverable under the right to know law. It's not how the message was created, how it was sent, or where the message is stored. It's the content of the message that determines whether or not it's a record and, in fact, a public record. Now, there's nothing illegal about using personal devices. Okay, and this was one of the very first legal cases to come out of the right to know law. And it basically says you cannot use private devices and private email accounts to hide the public's business. It is, it comes down to, does the message document a transaction or activity of the agency? So yes, I can use my personal cell phone for public business, but you need to understand that those messages are now discoverable. Worst case scenario, and I've actually encountered this, where a township supervisor's phone was sequestered as evidence in a court case, okay, because he had sent a message regarding a personnel action that resulted in a lawsuit. Okay. So that's worst case scenario. So you just, you need to be aware of that. I'm not saying don't do it. I'm just saying be aware of it, that any personal device can be used, but then it is subject. How would the open records officer even know that exists? Well, they would ask. Okay. And then it would be incumbent upon the officer to provide copies of those records. Now, let's say that there would be a suspicion that the officer was not forthcoming with all the records. Once the person files an appeal, it then becomes a legal action that either the district attorney's office or our office would be involved with, and we could issue orders to the officer saying, provide us with all responsive records. And if it were ever proven that they would not be forthcoming, they could find themselves in contempt, and judges obviously would not look lightly upon that. Okay, so I'm carrying this out further. I understand that depending on who the open records officer is, they may find themselves in a very awkward situation, asking for records from a personal device or personal account. But that, for the most part, is how it plays out. And like I said, if there is any suspicion that all the records were not provided, then the requester has the option of filing an appeal. And then once an appeal is filed, the legal apparatus start coming into play. And when you start getting orders from the Office of Open Records to provide certain records, that usually gets people's attention. The officer would be the one doing the search on their phone and having to provide an affidavit rather than the open records officer. Right. For the most part, that would be correct. It depends on how the orders are issued, but yeah, you're there. Once an appeal is filed, every bit of evidence is supported by an affidavit. You're getting ahead of me a little bit here, but I think they're good questions, and this is a good opportunity just to make that clear. And, the point being that you sign an affidavit that you're providing all the responsive records under penalty of perjury. And like I said, if you perjure yourself and the case proceeds far enough along that you have a judge involved, and that judge, then it actually goes outside of the world of right to know, and you're dealing with the legal issue of perjury. And if it's proven, then you're finding yourself in trouble. My recommendation, whether you're a police officer or, just a regular public employee, give the open records officer what they need. Okay. Don't try to hide anything, because ultimately it will come out. I mean, you think you're getting away with something, but that's usually not the case. Okay. Usually the truth comes out, and people find themselves getting in hot water over, trying to outthink the right to know law, or thinking that they're smarter than the people who are asking the questions or issuing the orders. And, like I said, I've worked with or in this office for 12 years, and the people are pretty smart. They can pretty much see between the lines when someone is playing a little fast and loose with the law. So I would be very careful. Okay, let's get back on topic here. And I think we've determined, okay, is it a record, and how that should be handled. So now we come up to, the other part of that definition. What are records? Any information regardless of its physical form or character. So yeah, we paper records would be rather obvious, but also electronic records like what we're talking about, emails, records of phone calls, text messages, and the like. Okay. And the question oftentimes will come up, well, what if the record has been deleted? The point being that, emails never really go away. The legal standard is if you have an email server, has the message been deleted from the email server? If it's still out there, and servers can usually hold a lot more data than a laptop or a cell phone or a desktop computer. If it's still on the server, then it's still accessible, and you would be obligated to provide it from that server. Um, Phone records, that's a little more complicated because usually to get records of phone calls or text messages that have been deleted from devices, you have to go to the cell phone provider. They have them because there's a federal law that says they have to maintain them, but usually they will only provide them with a subpoena. And under the right to know law, you do not need to issue a subpoena in order to discover records. So you contact the cell phone provider. They say, yes, we have them, but you need a subpoena. Right to know law, you don't have to issue a subpoena. So it's basically they're denying access. You made a good faith effort to get the records by reaching out to the cell phone provider, and that's all you have to do. Okay, you've met your legal obligation for a good faith search. All right, audio recordings, blueprints, we don't really care about for our purposes here. Security camera footage, I'm going to talk about in the next slide because we could be getting into the area of Act 22, which is a little different than the right to know law. But I do want to finish up this slide by talking about social media. Many departments have Facebook pages or websites where they post information, usually just to let the community know what you're up to. All right. Well, bear in mind that Facebook posts, website postings, and the like, there's a very good chance that they would be considered public records. Okay. But because they're already out there in the public domain, if someone submits a right to know request for a copy of, let's say, a Facebook post on your department's Facebook page, all you have to do is say, that's on our Facebook page. Here's the link. You can go copy it yourself. Okay, the right to know law allows you to do that. Same way with websites. Okay, that's on our website. Maybe they want a copy of the budget. That's on our website. Here's the link, and that's all you have to do. Okay, you've met your obligation because it's already out there in the public domain. If it's been deleted from your website, again, website posts, they might not be available or ready to the public eye, but they're still out there. Okay, they don't really go away. And the question would be, can you access it? With Facebook, deleted posts, real easy to get to. Deleted comments, real easy to get to. Okay, and there is case law that says if you can get it, but okay, if Facebook doesn't allow you to download the video, do you have to provide the video in another form? No, Walt. Since the video is already out there in the public domain, it is the requester's problem if they can't download a copy. All right, because it's already out there. And yeah, it's funny. I just went through that with a Facebook post with a friend last week where they put something up, but they didn't have the share feature. So I had to go online and ask them, hey, would you mind sharing this so I can put it on my feed? And I'm not a big Facebook guy, but you can kind of figure that stuff out. But you're under no obligation to share it if it's already out there in the public domain. It's their problem to figure out how to get a copy of it if that's what they want. Okay? But that's how you would deal with social media. And there is a body of case law with the right to know law and right to know law with law enforcement on sharing posts that are on websites and Facebook pages that you can find those on our website. Okay, let's move on and talk about Act 22. Now, it used to be that dash cam footage, body cam footage, security cam footage was accessible under the right to know law. But the law enforcement community was concerned about the amount of resources it was taking to respond to right to know requests for videos. So they lobbied the legislature for passage of a law that kind of reined things in, and it reined things in considerably. That law was passed in 2017. It's called Act 22. Now, listen to me. If a member of the public wants to get a copy of video for dash cam, body cam, or security camera footage, usually, almost always, they need to file a request under Act 22, not the right to know law. The Office of Open Records has no jurisdiction over Act 22. We have a page on our website that explains it, but that's only because when Act 22 was originally passed, nobody knew anything about what to do. So we kind of winged it, put our page up there. Now, I think we can say that the state police is the experts on Act 22. So if you have any questions on Act 22, I would suggest reaching out to them. They have contact information on their website as to how the law works, and they have experts within their staff that can answer questions for you. The only area where it's a bit of a question mark is when it comes to security camera footage. Okay, and here's a scenario. Let's say that your police department and the rest of the offices for your jurisdiction, your township, city, borough, whatever, you're all in the same building. And there's a camera out front that covers the front entrance. Now, if the monitor for the camera and the recording equipment are under the control of the police department, then it's Act 22. If the monitor and the recording equipment are under the control of the administrative side of the jurisdiction, maybe it goes to someone in public works, maybe it goes to the person at the front desk, okay, then it's right to know law. All right, so if it's law enforcement, Act 22. If it's not law enforcement, it's right to know law. All right, but under Act 22, if it's under control of a courthouse, well, again, it's going to come under who is the person that oversees the monitoring. If they're law enforcement, it's Act 22. And courts, yeah, who has control of the monitoring? Courts typically are not subject to the right to know law, okay? But it comes under who is control of the monitoring. Yeah, I think that's a good rule of thumb to use. All right, but back to Act 22. It's not right to know law. An Act 22 request needs to be submitted within 60 days of the video being produced. The police department has 30 days in which to provide a response to the requester. The police department can charge any fees that they deem reasonable. Under the right to know request, yeah, they pay me to talk. I always say that. Under the right to know law, for instance, you can't charge for labor. Under Act 22, you can. And then if you deny a person's request for a copy of the video, the appeal goes directly to court. You do not stop at like the Office of Open Records. We have no involvement with Act 22 whatsoever. I'm just providing this for the good of the order because there's, you get these requests for video and oftentimes you don't know what to do. Okay, now something else that I want to put in here is that under Act 22, the definition of a law enforcement agency is any agency that employs a law enforcement officer. Okay, that could be a school district. It could be a charter school. It could be Amtrak. Okay, under Act 22, they're defined as law enforcement agencies. Okay, but not under other laws, and we'll talk about that. Can we partially deny a right to know request if it includes a request for body cam or police cam footage? Yeah. And what I would do is try to be as helpful to people as possible. But ultimately, you are denying the right to know request. Okay, you're saying, For instance, you use the word partially. So you're saying we're giving you these records because we've determined them to be public, but the video that you're requesting is not accessible under the right to know law. And by the way, this is Act 22, and here's, I would give them a link to a copy of that law and probably a link to the state police's website on their Act 22 page. Again, and it all goes back to educating the public, because if you throw, well, we're just going to deny your request for video and not tell them why, which you are obligated to tell them why, but if you don't, it's just going to frustrate them. And they're going to get more and more upset and probably get uglier with you. But if you try and educate them and say, look, that is accessible under Act 22, or may be accessible under Act 22, then, it makes life easier for everybody, you and the requester. So that's what I would recommend that you do there. Okay, so enough with Act 22. Let's move on and move up to the second hurdle, where again, we're trying to determine, is this now a public record? We've already answered the question, is it a record? Now we need to answer the question, is it a public record, which is different? Okay, so remember I said in front of the second hurdle, there are 3 hoops we need to jump through. With the first hoop, we need to answer the question, are there any exemptions that apply? And if so, are we going to invoke them? Now, an exemption you can find in Section 708B of the Right to Know law. Just real quickly, there are 30 total exemptions. But for our purposes, we're only going to talk about 3. An exemption is a definition of a record that has some confidentiality considerations. And the exemption basically says you can withhold these records if you want to, okay? Because the right to know law is not a confidentiality law. It is discretionary, meaning you can release a record if you want to, but you can also withhold it if you want to, provided it meets the definition of one of these exemptions, okay? Then we come up to the second hurdle. Are there any federal or state statutes or a judge's order that make these records private or confidential, non-public? All right, and we'll talk about that here in a minute. And then the third hoop is the record protected by privilege? Okay, so yeah, first offhand, let me talk about federal or state statutes. For police departments, this is an important one. There is a law called CREA, the Criminal History Records Information Act, that applies to law enforcement agencies, and it defines types of records that must be withheld from the public and can only be shared with other law enforcement agencies. And it's law enforcement agencies as defined by CREA, just to distinguish from Act 22. Remember, with Act 22, I said that a school district could be a law enforcement agency, not under CREA. Under CREA, we're talking about like Act 120 certified, et cetera, et cetera. Okay, a much tighter definition of a law enforcement agency. Okay, and what makes CREA different from the right to know law? Well, number one, it removes the discretion. CREA doesn't say you may withhold these records. It says you must withhold these records. And CREA includes sanctions. You can be sanctioned for violating CREA. The other thing to keep in mind is that CREA embraces a much broader scope of records when it comes to law enforcement type records. Okay, for instance, under the right to know law, we're going to talk about an exemption, 708B16, that involves criminal investigatory records that you can withhold. Well, the right to know law doesn't say anything about criminal intelligence records. Okay, so if I submit a right to know request for copies of your file that deals with suspected gang activity in my jurisdiction. I'm not going to find anything that prevents me from releasing that or that gives me the power to withhold that in the right to know law. But if I go to CREA, this other state statute that says I cannot give out criminal intelligence information, that's the law I go to meet my legal burden that says we're not going to release these records. Remember, going back to the beginning, every record is public unless I can prove otherwise, and I have to meet my legal burden. So I refer to the appropriate language in CREA that says we cannot give out criminal intelligence information. Thus, I don't make it through the hoop. I can't jump over the second hurdle. I'm off the course. Okay. And there are other laws that make records non-public. Okay. But CREA is the biggest one that you want to be familiar with. Now, how do you find out more about CREA? You go to the Pennsylvania Attorney General's website, where they have a guidebook on CREA, and they have staff that are up on this law and can help you out if you have questions about some of the language in there. But two things to keep in mind. One, CREA says you only share this information with other law enforcement agencies. And two, it removes the discretion that you have with the right to know law. And by the way, the right to know law defers to CREA. Okay, it removes any discretion if the record is covered by CREA. You cannot release it because you're legally obligated to only share it with other law enforcement agencies. Then we come to the third hoop. Is the record protected by privilege? And here we're talking about attorney-client privilege. Any record that deals with sensitive issues between an attorney and their client is protected by attorney-client privilege. And you go to Section 305 of the Right to Know law, and it recognizes attorney-client privilege. And that would include communications between a solicitor and the department that deal with sensitive issues. So attorney-client privilege would apply, and you would refer to that section of the Right to Know law as your basis for not giving up those particular records. Okay, so I promised to talk about these exemptions. Let's do that now. There are 3 of the 30 exemptions within the Right to Know law that a law enforcement agency should be familiar with. The first and most common one is 708B16. And essentially it says that if a record is critical to a criminal investigation, then you can withhold it from public release. It does not have to be an active case. It could be a 25-year-old cold case that was solved, conviction, person's in prison, person's released from prison, whatever, okay? It could be a cold case and you could still invoke 708B16. Now, if your department uses a blotter, which, you know, a blotter is basically a diary of shift activity. You know, at 3:08 a.m., officers were dispatched to this particular address for a complaint. Okay. Most departments have something like that. Okay. That information is public, and it's specifically referenced in the Right to Know law that it's public. Okay. But let's say you get a request for an incident report. Okay. And this would be after the incident, the officer comes back and completes a report that memorializes what took place. Okay. There is a court case law available that in essence, it says it's coming out of the Commonwealth Court, 2010, I think, where the Commonwealth Court said, incident reports are inherently investigatory, therefore the B16 exemption applies. Incident reports are not public records. Okay, so you can withhold a police incident report if you deem that you want to do that. Okay, incident reports are not public records. Okay, moving on. What if it's Okay, what if an agency releases a criminal investigatory records in one records request? Yeah, you're not establishing any legal precedent by releasing an investigatory record with one case, and then you receive a right to know request for investigatory records for another case. Okay. As long as your policies and procedures are not arbitrary or capricious in any way, facts change, from one case to another. What was the case law saying? Incident reports are not public records. Yeah, I believe it's either 2010 or 2012. And the case citation, I don't have the exact court citation, but it's state police versus Office of Open Records. Go to the Office of Open Records website and look in the case law index, and you'll find the citation there. It was Justice McCulloch of the Pennsylvania Commonwealth Court, and yeah, she made that statement. Incident reports are inherently investigatory in their nature. All right, can a record be released with redacted information removed from it? Yes, it can, Brian. However, keep in mind that a redaction is a denial. So let's say you've got a Social Security number, okay? Under the Internal Revenue Code, Social Security numbers are considered confidential. So you redact it, you black it out. Well, in your letter where you're granting access to the record, hey, there we go, Walt, thank you. In your response, you would say, we're releasing the record, but we have redacted a Social Security number. You have to tell someone what is behind the redaction in general so that they know you're not withholding anything you're not supposed to. And redactions can be appealed if they disagree with what you're covering up. Okay. Another good questions, guys. And Walt, thank you for the citation. Okay, so what if it's a non-criminal investigation? For instance, let's say you're a small department, you're a small jurisdiction, you don't have a codes department, but you have a police department. Someone calls in complaining about their neighbor's yard. Okay, a bunch of trash hasn't been mowed, whatever. Well, guess who gets sent? Okay, the police department gets sent. But it's a non-criminal investigation. Well, someone submits a right to know request. I want to know who complained about my yard. All right. Well, under this exemption, you can withhold any record of a non-criminal investigation. Suicide. Okay. Police department gets dispatched for what is obviously a suicide. Okay. There's no evidence of any criminal activity whatsoever. But someone submits a right to know request for, I want a copy of the note because I'm being nosy. All right. Well, you can deny access to that note because it is a record of a non-criminal investigation. Okay, so you can withhold it. But keep in mind, in order to invoke this exemption, you need to have the legal authority over that non-criminal aspect. Okay. Just to be clear, non-criminal investigatory records for non-police departments are also exempt, correct? Yes, however, like I said, you must have legal authority to invoke that non-criminal investigatory record. In saying something like, okay, this actually happened. Someone submitted a right to know request to a school district for records. And the school district said, well, we're looking into this, so we consider this to be a non-criminal investigation. Well, the school district had no legal jurisdiction over this particular issue. So they could not define it as a non-criminal investigation. A township once tried to say that a right to know request initiated a non-criminal investigation. Therefore, they were withholding all records related to the right to know request. Didn't fly because they had no legal authority to invoke a non-criminal investigation. All right, so you need to be careful of where you're coming from when you use that. If a police department invokes it for instance, say for an obvious suicide, well, they have legal jurisdiction to do so because they have a legal obligation to investigate suicides. Same way with codes enforcement. Somewhere within that jurisdiction, there's a signed document that says the police department investigates code complaints. Okay, so they have a legal authority to invoke the non-criminal investigation. I'm getting into the weeds here, but it answers your question, Walt. So you just need to be careful about how you do that. Okay, and then the third exemption that you need to be aware of relates to copies of emergency dispatch information, your 911 centers, your county 911s. Someone will submit a right to know request. I'd like a copy of the recording that someone, called in for this emergency dispatch. Well, using Section 708B18, the Emergency Management Authority, usually it's the county EMA, they can withhold copies of all recordings, whether it be telephone or radio dispatch, inter-unit communications and the like, okay? Any communication captured through 911 or emergency dispatch can be withheld. Can a civil attorney get incident records because the person is a client? They can, but they would need to use subpoena powers rather than right to know. Okay, and also it comes down to whether or not the department would want to invoke the exemption with right to know. Okay, because remember, the right to know law is discretionary, and sometimes it might just save everybody a lot of trouble. Hey, I need a copy of this incident report for my client. And sometimes here's a very real life example. There's a burglary and someone wants to file an insurance claim, but the insurance company says, well, we need a copy of the police incident report. Okay, so they file a right to know request. And there's nothing, there's nothing troubling in the incident report. So why not just give it to the person so they can get their claim settled? All right. So that's what I would do. And sometimes it's just a matter of having a conversation. There's nothing in the right to know law that prevents you from talking to each other. Okay, so if a person files a right to know request for an incident report, and you would say, well, incident reports aren't public, but then the person says, well, look, I need this for an insurance claim. What's preventing you from giving them what they need to help them out? Okay, all right. Walt, if two different people call in for the same recording, and if the agency grants access to one person, do they have to grant it to the second person as well? I would be very careful about that, and it's going to depend on the circumstances. And I think under Act, you're asking an Act 22 question, and I'm not an expert on Act 22, but I think with Act 22, the person might have to explain why they want it. All right. So, Walt, my answer is it depends. And I'm sorry I don't have a more succinct answer for you. But I think under Act 22, that's probably the best answer I can give you. All right. So, yeah, we've talked about the exemptions. Let's talk about appeals. Okay. Act 22 is more stringent and you have to be a party to the incident. Yes, yeah. Thank you for answering that. That's what I meant. Okay. Yeah. Always qualify your statement, but I think you're right there, Mark. I think that's probably the best answer you're going to get. Okay. So appeals. This is important for law enforcement. Under the right to know law, if you deny a request, and you use 708B16 as your legal basis for meeting your burden, the appeal does not come to the Office of Open Records. The appeal goes to the county district attorney's office if you're a local agency. If you're state police, then it goes to the Pennsylvania Commonwealth Court. Okay, but all other appeals would come to the Office of Open Records. Okay, let's talk about costs with the right to know law. And essentially, real quick, the right to know law is not free. Okay, you can charge for responding to right to know requests. And in a nutshell, it's 25 cents a page for 8.5 by 11 or 8.5 by 14, single-sided black and white. Okay, you cannot charge for electronic records. There's no charge for copies of emails or the like. Everything else, is actual costs. Like if you have to mail something out, you could charge them for whatever the postage fee would be. You cannot charge for labor under the right to know law. And if there are any other legislated charges, well, they take precedent. You can charge for them. And I cite accident reports here. Someone files a right to know request for an accident report. Well, their release is governed by the Pennsylvania Motor Vehicle Code. And under the vehicle code, there is a fee schedule, and it's something like, I think it's $15 outside of Philadelphia. Okay, I don't know why they get an extra $3, but so accident reports, their charge is legislated by the Motor Vehicle Code, so you can the fee schedule for right to know no longer applies. It's trumped by the Motor Vehicle Code fee schedule, which is the $15. Under right to know, 25 cents a page. Under under the vehicle code, accident reports are $15. So essentially, we are only allowed to charge it for electronic records if it is under Act 22. That is correct. There are limited circumstances where you can assess a charge for electronic records under the right to know law, but it's very limited. And we cover that, I think, in the webinar dealing with the fee, right to know costs. Okay. Moving on. Yeah, we're at the final slide. If you have any other questions, now's the time to get them in. But in the meantime, I'm just going to talk about, what other resources are available to you. I think we've pretty much covered everything you need to know with right to know law for law enforcement. First offhand, I'm just going to tell you, this is the best government website you'll ever find. It gets updated 6 days a week. Okay, can you deny an electronic copy to a personal email address? Yes, and make them get a hard copy. Okay. Let me think through this. Okay, personal email addresses, addresses are considered confidential. Okay, there is some case law on that from the Pennsylvania Supreme Court, where they cite what's called the constitutional right to privacy. Okay, so personal email addresses are confidential. So if someone submits a right to know request for a copy of an email that includes a personal email address, you would deny access to the electronic copy of that email, because there's no way you can delete that personal email address. So yes, you would say that the only way we'll give this out is by generating a hard copy. And then with the hard copy, you would redact the personal email address. Okay, so yeah, your logic is sound there. And they would have to pay for the hard copy. Now you're getting into the payment issues webinar, but yeah, you see where we're coming from. You would not provide the electronic copy. You would make them get a hard copy, and they have to pay for it. All right. Let me back up here with some of these comments that are coming in now. Okay, we got that. We got that. Now we're up to under Act 22. You said the person must be a part of the incident when making the request. Okay, I'm not 100% positive on that, but I think what if it is an attorney asking on the involved party's behalf? I think that would satisfy it. Okay, the attorney has been, in essence, contracted by the person to act on their behalf. So that's a legitimate relationship. Sorry, they want me to send it to a personal email, not an email. Oh, okay. Lieutenant, then in that case, that would be legitimate. An email address is considered an address. And I think well, I know that there is a decision validating that. Just a little bit of background here. In the right to know law, it says that a requester must provide an address. So the question came up, is that a physical address or would an email address be okay? And in the context of the reasoning for that, where it basically, you need to tell us how to get a hold of you, okay, where we can send the response. So an email address is considered a valid address for right to know purposes. Okay, let me try and scroll down here again, because I think some others have come in that I may have missed. Okay, yeah, I got that. Can you ask for more than one 30-day extension? Yes, you can. However, only the first 30-day extension is unilateral. Any extension past the 30 calendar days, the requester must agree to in writing. And that's because if things go south, you've got that agreement that says, that the requester agreed to go beyond the 30 days. If they don't agree and you miss your deadline, then it's considered a deemed denial and they can appeal that. Okay. They are asking if the agency can deny sending records through email to make a person come to get the records. No, if they provide you an email address and it's all electronic records, you send it to the email address. If it's hard copy, then you work out how you want to proceed with it. They can come pick them up, or you can mail them. And like I said, you can charge them for the postage. Okay. Form requires to explain your relationship to the request. And it's okay. There you're talking about Act 22. Yeah. And like I said, none of us are experts on Act 22 around here anymore. But Mark, thanks for posting that link. Yeah, I know a lot of you have questions on Act 22. We're just providing the basics because it always comes up. When this first happened, like no one in Act 22 was assigned as like the point agency. And because it had been Office of Open Records, we were still getting questions. So we posted up on the page and we did our best to answer questions. But now you want to go to the state police. Okay, the state police will answer your Act 22 questions because they have a lot of experience with it now. And they have some good staff over there who can get you steered in the right direction. Okay, any other questions? Like I said, now's the time to get them in. Yeah, I think we've answered all of these that we have in the queue. If you do have further questions, the contact information was on the screen initially. How did I get back here? Okay, let me scroll forward. Something happened that we got backed up here with our slides. Yeah, there we go. Okay, contact information is on the screen right now, and you can reach out to our office. May we get a copy of the PowerPoint? Yes, you can, Monica. It's on our website. Go to the training tab, scroll down, you'll find the PowerPoint. As I did in my opening comments, you can find all the PowerPoints for all of our training, and you can use anything you want. Okay, it's there for you. So if you do have any further questions, again, feel free to reach out to our office. We'll get you steered in the right direction. Really good session today. Is it recorded? Yes, you guys just weren't listening at the beginning of the presentation. The session is being recorded and it'll be posted on the website in a couple days. Okay, so you can download it from the website. Yeah, I think I've covered everything. I want to thank you for good questions today and good discussion. And yeah, stay warm, stay safe out there. And thank you for all you do. And we'll see you in 2 weeks where I believe we're going to be talking about basics of the right to know law. Okay. Thank you, everyone. We're going to log off.